appointing.
I think you said earlier that at-will removal gives the Secretary the power to influence the content of recommendations before they're made. Is that accurate?
I think that's correct, Your Honor.
And then, because that comes from the at-will removal power, correct?
Correct.
And how is that then square with the word independent?
Because it's still the task force ultimate judgment that matters. Yes, they can consider what the Secretary wants. They may be even influenced by the fact that if they don't do what he wants, they might get removed. But it's still ultimately their call as a statutory matter. So I would point, for example, the benefits review board.
That's an odd definition of independent, I suppose. Does independent in this context have any different meaning because the folks in question are not government employees, that they have outside affiliations, their employers, or wherever they're affiliated with?
Well, we do think that they are officers of the United States, so we do think they're government employees. But your point that they have other affiliations as well, we do think that's part of why—
They're not paid, right?
Yes, they're volunteers. But we do think that that's part of the reason why it uses the phrase independent, to underscore that it's not just that they have the power to make the judgment based on their best scientific judgment, they have the duty.
But I hear you as not relying on the notion that independence in that provision means independent from, your university or your think tank or something like that. That you think that the word independent here does mean independent from political influences and particularly from presidential ones.
Well, in making the recommendation, we think that they have to exercise their best scientific judgment free from all of it. They shouldn't do what their university tells them to do. They shouldn't necessarily do what the Secretary tells them to do. They should exercise their independent judgment based on the science.
But the Secretary might say, and I think you acknowledge this, if you don't make the following recommendation, I'm going to fire you.
That's right. And so the analogy I would give you, Your Honor—
That's okay, right?
Yes. The analogy I would give you is the Benefits Review Board in the Department of Labor. So the Benefits Review Board in the Department of Labor is an adjudicatory body that is at-will removable. Because they adjudicate cases, they should adjudicate cases based on their view of the facts and the law. But it's true that if the Secretary tells them, look, you come out one way, you're going to get fired, they might get fired, but they should still exercise their independent best judgment when they issue the ruling.
Well, what's this language "to the extent practicable" doing?
So, I think that it's not entirely clear, Your Honor, but I think that, if anything, it underscores our point that you should not read this statute, especially in light of constitutional avoidance, to say that the Secretary can't exercise the types of review we've said.
I mean, it does suggest that Congress was thinking in some circumstances it would not be practicable.
Right. There's at least—
And what circumstances would Congress be thinking that about?
Well, at a bare minimum, the circumstances where the statute would be unconstitutional if the Secretary couldn't engage in that level of supervision. So, I think that language just underscores the constitutional avoidance point that the limited forms of review that on the back end that we've emphasized have got to be permissible under that statute, both because it has that language in it and because the canon of constitutional avoidance says you should read it that way. And again, going back to the adjudicators, it's not just the Benefits Review Board. More generally, under the APA, the statutory scheme for adjudication has exactly this feature to it. You have adjudicators who are tasked with exercising independent judgment, but their actions on the back end can be reviewed.
Yeah, I understand the analogy to adjudicators, and I thought that's what was in your brief, but normally you wouldn't say with adjudicators that the supervising officer can influence the content of the adjudication.
Well, yes.
They can only review the adjudication after it's been made.
Well, but they also, as the Benefits Review Board says, you can also influence it. You have at-will removal. And every one of these adjudicators knows that they're acting under the shadow of that. So, does that affect them? Perhaps, but their duty and their power is still to make the decision based on their best judgment. Perhaps one way of making the point is—
And so you're making the analogy, though, to adjudicators here, right? You think that's a good analogy, and because their recommendations can be reviewed before they take effect, it's similar to all the adjudication cases where there's been supervisor review of the ultimate decision.
That's right. And one way of making the point is, for these individuals, if the Secretary tells them to do something and they don't do it, they do the opposite and make a different recommendation, that's not insubordinate, right? Because they have statutory power to make their independent best judgment. For most inferior officers, If the president or your head of your agency tells you to do X and you do Y, that is insubordinate. So that's what the language does. Now, that doesn't mean that you need to be protected from removal on the back end. You can be independent, make your own statutory judgments, but then have to face the consequences if the head of the agency disagrees with those.